Hello, everyone, and thank you for joining today's webinar, Contractual Duty to Defend. Are you managing your risk? As you get settled, please feel free to say hello and where you're joining from in the chat today. A few quick housekeeping reminders. Today's session is being recorded and qualifies for one AIA learning unit. For those who stay on and watch live, AIA California staff will report these units to AIA for you and will send follow-up information on how to receive your certificate of completion. There will be a Q&A session towards the end of today's webinar to hear from attendees. Please use the Q&A box to submit your questions to the panelists. You can also like a question to move it to the top of the queue. Please be constructive in your comments and questions to help foster a positive learning experience for everyone. To qualify for continuing education credit, AIA California provides learning objectives for every webinar and includes them in the presentation that can be made available online. And now I'd like to introduce our speakers for today. First, we have Laura Noss. AIA is the President and Chief Practice Officer of Lionakis, a 200-person architecture, structural engineering, and interior design firm with 5 offices in California. Laura has worked as an architect designing California schools for more than 35 years. She currently serves on the Division of the State Architects Public School Construction Consortium, vetting policies affecting the school design and construction industry. And she is also the current Vice President for Government Relations at AIA California. Next, we have David Barker, Esquire, is a trial attorney at Collins & Collins and has represented and counseled businesses, nonprofit organizations, foundations, and public entities on issues of product liability, professional liability, general liability, and transactional matters. He serves as lead trial counsel representing clients in federal and state courts and in arbitration and in matters of contract disputes, negligence, and other claims. Mr. Barker also frequently assists clients with issues related to administrative boards and bodies, as well as with copyrights and trademark issues, including registration and defense and prosecution of infringement claims. Next, we have Brett Stewart, Esquire, who is the manager of the Loss Prevention and Education Department for the Design Professional Unit of AXA XL. He is responsible for leading the efforts to develop risk management and educational materials for AXA XL's design professional insurance to help firms manage their liability and business risks. Brett interfaces directly with architects and engineers, brokers, and various industry organizations to promote issues that are relevant to the design community. Prior to joining AXA XL, Brett was a litigator at 2 San Francisco law firms where he specialized in construction-related disputes. Thank you all so much for being here, and I will now hand it over to Laura.
Thanks, Sarah. Thanks so much. Thank you, everyone, for joining us today. And especially thank you to Brett and David, who took my call when I asked them to be part of this webinar today. As Sarah mentioned, as VP of Government Relations, I chair the Advocacy Advisory Committee for AIA California. And while our committee has some big picture advocacy that we support or lead, housing, climate action, for example, we're also focused on trying to tackle the day-to-day issues facing our profession today. While those can't always be managed with specific legislation or regulatory change, that is our goal. But often it starts with some basic education. Past efforts, for example, on QBS, qualifications-based selection, include AIA outreach to clients violating those principles. And that is the kind of effort and where we start with a lot of these, what I like to call the stones in the shoe that we deal with in practice every day. Other areas on our radar right now are focusing on retention of architect fees, uncompensated design competitions, and those ongoing attempts to elevate the standard of care. And of course, today's focus, the upfront duty to defend, that is a regular part of many contractual indemnity provisions in contracts coming from a wide range of client types. You all will make your own business decisions regarding contract risk. Today, though, we're here to talk about managing that risk and communicating that risk to prospective clients. Our agenda today focus on some of the basics as well as negotiation strategies, ending specifically with what we're doing about it at AIA California. Next, please. So what's our starting point? It's where architects, I think, always start, and that is that we want successful projects, happy clients. We're always going to be responsible for our mistakes, that we want contracts that are clear and unambiguous, that are built on relationships, really, and that our obligations should really be based on that fairness and reflect the things that are part of what we can control in our day-to-day work. And so we're going to get started with David and Brett giving us some lively 101 on contract and insurance basics.
Well,
Guys?
thanks so much, Laura, and I will always answer your phone call. So thanks for having us on this today. So I want to speak a little bit about some contract and insurance basics. We'll kick this off. Next slide, please. Whenever we're going to talk about indemnity, I want to just pause and make sure we all know what we're discussing. And then when we get into the duty to defend, just sort of lay a little bit of groundwork for that. Indemnity is a risk transfer mechanism. It's a thing that shows up in your contract. It says up front who's going to be responsible if something goes wrong. If something happens on the project, who's going to bear that loss? And a lot of times what we have within that indemnity provision, we'll see a clause here in a couple of slides, is this duty to defend, right? We're talking about defense costs. If something goes wrong, your client may say, well, I want you to be responsible for this loss. I also want to make sure that you pay my legal fees. When we get into talking about these things, there's paying legal fees at the end of the case, and there's also just hiring somebody, an attorney. Two vastly different issues that David's going to talk about, and I'm going to talk about throughout this program. When we talk about the duty to defend, what we're really talking about is writing a check every month. Next slide, please. So this is a clause. You're going to see this clause a couple different times now and then later on in the program. This is just sort of a generic indemnity clause. There's a lot of things that we are going to have an issue with this. You can see where I've highlighted some of these words like defend. When we talk about the duty to defend, I said it's part of that indemnity clause. There's the word defend, and that's got some legal significance. We'll also talk a little bit as we sort of peel back the layers of the onion. Who are the folks that we're going to actually hold harmless? Right? Who are the indemnities? And then what are we going to indemnify them from? And then what is that trigger? That is it going to be our negligence? Is it going to be anything arising out of our services? Next slide. David, I'll hand it over to you on this one.
Okay. So thank you, Brett. And as Brett indicated, the duty to defend is a little bit of a different animal. And in a few slides, we're going to get into some code sections that really talk about where it comes from. And I'll sort of give you a very brief law school 101 on those issues. As Laura was talking about, the goals of the project, everybody's in the same position. And one of the things that I love about working with architects, you're professionals. And you'll stand up and say, I'll be responsible for my own problems. But what we really want to try to make sure is that you're not in the position of paying for somebody else's issues. And part of that is also making sure that you're not paying for the lawyers that are defending your client or anybody else until we know if you really did anything wrong. So with that, I think we can go to the next slide. And Brett, I think that one goes back to you.
Right. So I want to just kick this off a little bit with talking about your policy language and what does your insurance respond to. And I've got a couple slides on this. I know for a lot of folks, this is super boring, but when we get into managing our risk, it's really important to know, well, what does insurance pay for? What does your policy respond to? And then where does that stop? Where that policy coverage stops, that's where you start making business decisions. That's where you have some skin in the game. And I rarely tell our insureds not to do things. I just want you to go into it with both eyes open. Part of that is having a basic understanding of what your policy covers. Now, what I've done is I've just taken the policy language, copied it from our insuring grant and the AXA XL policy. Virtually every design professional policy is going to have language very similar to this, if not the same. And what your policy does is it responds to a claim, which is a demand for money or services that arises out of a wrongful act. Wrongful act means an alleged negligent act, error, or omission. So basically, your policy responds to if somebody's been damaged due to a breach of the standard of care, you failed to maintain that standard, you were negligent in providing your services. That is what your policy is there for. Next slide, please. One of the things I really want to point out, and in terms of like takeaways in this program, I think this is one of the most important ones. Every professional liability policy that I'm aware of has this exclusion. It's a contractual liability exclusion. And what that basically says is nothing you agree to by contract is insurable unless you owe that obligation in the absence of an agreement. That's a pretty powerful exclusion. I think it's the most important exclusion in your policy. And when you're looking at your contracts, when you're trying to negotiate agreements, it's important to know, where does my insurance stop? And this is a big place when we're talking about the duty to defend, for example. We're going to talk about things that you would not owe in the absence of insurance. Well, guess what? That's where your policy, you're going to run into a problem with the contractual liability exclusion. Next slide. Now, in our policy and the AXA XL policy, and some of our competitors do this as well, in our definition of damages, we give something back in that policy. So you take it away with some of the exclusions, like the contractual liability exclusion, and some of the definitions give coverage back. What this says is, I didn't copy the whole thing, but the policy will will provide reimbursement of reasonable defense costs that your client incurs caused by your negligence. That is a huge carve back in this policy. And what I think is really significant about this is when, and David's going to talk about 2782.8 and the anti-indemnity statutes. When that statute was passed, David, I think it was back in 2018 now, early in the stages when we were trying to get this across the finish line, we were interacting, we were engaging with industry groups, and the initial bill had this language in it. It had reimbursement language in it. And that was a great idea, because what that meant was, for us in particular, this was in our policy language, you had the second largest commercial carrier in the world standing behind a promise to reimburse your client their reasonable defense costs. As we engaged with industry groups, a lot of folks had trouble kind of grasping this. And I think a lot of the reasons for it, and David may get into it at some point, is your policy is different than a contractor's policy. Contractors can provide this contractual coverage, but your policy, professional liability policies, don't do that. They provide a whole lot of other coverage that a contractor's general liability policy doesn't cover. But this is one of the areas that I think a lot of folks had trouble grasping. And at the end of the day, this bill was shot down. So I'm going to turn this over to the next slide. And David, you want to walk us through, I think, a couple statutes that are pretty important to lay the groundwork for this.
Yeah, absolutely. So as Brett was saying, there's an exclusion under your policy for obligations that you incur by contract, unless you would have that obligation without the contract. So when we talk about the duty to defend, that only arises if you have an express indemnity clause. So if your contract does not have an express indemnity clause, then you would not have the obligation to pay for the defense of somebody else. That's why that's a classic scenario of something your carrier would not be obligated to pay for. So where does part of that come from? Well, we've got California Civil Code 2778, which has been on the books since 1872, at least originally. And this is a code section that defines and addresses how to interpret indemnity clauses. And this isn't just for A&E contracts, this is for any contract. Part 3 of that code section, which is blown up a little bit here, talks about an indemnity against claims, embraces the cost of defense. And what we had was, back in 2008, there was actually an important California Supreme Court decision called the Crawford case that came out and said, there's an obligation to pay for the defense, whether you did something wrong or not. Now, one of the important issues here is that when you look at the opening language of 2778, towards the end of it, you'll see it says, unless a contrary intention appears. And I want to put a pin in that for us to circle back later on when we look at some specific clauses and talk about how you can deal with things. Can we go to the next slide, please? So in 2007 was when 2782.8 was initially passed. That was the very first version of it in 2007. And at that time, it only applied to local public agencies. Particularly when we talk about things like indemnity, the legislative efforts on this have to be taken in baby steps. I was actually fortunate enough to be one of the people that participated in working on this language and even going up to the legislature to try to get it passed. And we actually heard some people saying, well, gee, why is this so limited? Well, we've got to take a little step at a time. So in 2007 was the first version. It was modified then in 2010. And then, as Brett was noting, in 2018 is the current version. And this is important because now it's not limited to public agencies. It now covers private contracts as well. Again, there's a little bit of an asterisk on that we'll come back to. And I want to take a moment and talk about this paragraph A of 2782.8 and really talk about what it covers and addresses. So first off, it's any contract or amendment after January 1, 2018, where the contract is for design professional services. So if it's design professional services, this applies. But then the next word is important. All provisions, clauses, covenants, and agreements. So it's not just the ones that pertain to professional services. It's not limited to certain things. It's the entire contract has to comply with this. And then what we see as it goes down, and that's the part that we have blown up on the left-hand side of this slide, is that in no event shall the cost to defend charged to that design professional exceed the design professional's proportionate percentage of fault. Well, that's an important concept because any of you that are looking at contracts, you've probably seen these provisions that come out that say, okay, you pay all of our defense and then we'll pay you back. Well, here's the trick. At the start of a lawsuit, how do you know what your percentage of fault is? And so you're not allowed by code to pay more than that. So how are they going to charge you all of that, thereby breaking this law, and then pay you back later on? And that's actually one of the negotiation points we'll talk about here in a little bit that I get into quite a bit, is the defense really should get pushed later on as a reimbursement, as Brett was already talking about. Oh, I got behind on my slides here. Can we go to the next slide, please? So 2778 gives us this concept of an immediate defense. But then what we see in 2782.8 is that there are certain limitations when we're talking about a contract for architectural or engineering services. I want to point out that it is for professional architecture, engineering, and landscape architecture. So CCIDs, interior designers, not covered, or unlicensed designers, not covered. Now, I will also tell you, no court to date has interpreted 2782.8. So we don't know how that might actually shake out. I have a number of clients that come to me and say, well, gee, why should I care about negotiating the indemnity clause? I've got a law that's in my favor. Well, one of the problems is that at any point, a court could come out with an interpretation that overturns the statute or interprets it in a negative way. And you would hate to be stuck with an indemnity clause if something goes wrong. So rather than that, rather than use it as a shield, I use it as a sword to try to negotiate and change those indemnity clauses. It's also important to understand that part of the reason that 2782.8 got passed was in order to align with what the insurance covers. And I think that you can also use that as part of your talking points. Doesn't your client want to have an indemnity clause that will actually be covered by your insurance? And ultimately, as we talked about the overall project points, the goal is to create a contract everybody can live with. But one of the things, and this was one that Brett really brought up as we were preparing for this, and I liked the way he phrased it, you should look at 2782.8 as a ceiling on your obligations. In other words, you shouldn't do more than what 2782.8 provides. A lot of times we see contracts that come out from owners, school districts, commercial owners, whatever the case may be, that they try to use it as a floor and then get more than that. No, that's the ceiling of the most that you should do. So with that, I think we can go to the next slide. So we're going to dive into and look at a couple of different actual indemnity clauses and talk about some of the different approaches to this. And here's three general approaches. Now, like any lawyer, I'm going to tell you there's an exception to every rule. There's more actual approaches than this, but they all kind of generally fall in these big buckets. The first one is no change. Just go ahead and defend and indemnify for everything except your client's sole negligence or willful misconduct. By the way, that exclusion, sole negligence and willful misconduct, is a different code section that's also been on the books for a number of years. The second approach is the reimbursement. Now, this is the better reimbursement, and this is the one that Brett was talking about. This is, you would reimburse your client for its reasonable defense cost after it's determined your percentage of fault. The last one is the full defense, that you're going to go ahead and provide the full defense, and then you'll be reimbursed by the client. As we already talked about, that could be an issue because at that point in time, first off, there's no coverage. So you're writing a check every month to pay for their lawyers. And secondly, how do we know what your percentage is? And in a few slides, you're going to hear from Brett talking about sort of that pay and chase approach. Can we go to the next slide? So if we look at that clause that Brett gave us, consultant shall defend, indemnify, and hold harmless client from any and all damages that arise out of, pertain to, or relate to the negligence, recklessness, or willful misconduct of consultant. Let's talk about the no change to indemnity. Court could uphold the immediate defense obligation, or they could strike 2782.8, which says that it's void and unenforceable. If you don't change the language, then you're going to be stuck paying those bills. And under the 2778 language in those court cases, you would have to pay for those defense fees even if you did nothing wrong and you didn't have to indemnify. We've also talked about this concept of a bifurcated indemnity. Anybody that's reviewing contracts has probably seen this, where you have an indemnity clause that says, for all professional services, here is your indemnity obligation. For anything else, here is your indemnity. And they're very different. The problem with that, as we talked about, is the code section says all clauses and provisions of the contract. So I don't think that works. But when we also look at what architects do, I've been doing this quite a number of years, and I'll tell you, there's not an awful lot that falls outside of professional services. So if it's a push come to shove, it's certainly not the worst scenario. We go over to the reimbursement concept. And here's some language that's not in the clause, but this is the type of language that we might add on. Consultant shall not be required to defend the indemnities, provided, however, consultant shall reimburse the indemnities for the cost incurred as a result of such defense. So now in the contract, you're setting a formula that's going to be based on your liability. And as Brett talked about, certainly under his policy and under a number of other ones I'm familiar with, that would likely be paid for by your insurance. And then the consultant reimburses the actual defense cost for its own issue. You can see how we've even modified that language a bit more. Professional shall be obligated to reimburse such indemnities for that portion of the defense cost reasonably incurred, which is attributable to the portion of damage caused by or attributable to professional or its agents. The goal here is to limit your obligation to reimburse defense to your proportional fault as it's determined by a court or a jury. Next slide. The last one is the full defense. And this is the tough one. We've already talked about that. The consultant shall not be liable to the extent, only to the extent consultant can demonstrate any liability, loss, damage, and cost arise from their negligence. And this is language from an actual clause that we've seen. This puts the burden on you to show that the claims against your client are not caused by you. Well, that's not what the code says. And what do you do about third-party liability? Under this kind of clause, you would still be obligated to pay for the defense, even if the contractor caused the fault or something else. The middle box that we've got here, in the event the client is found by a court or arbitrator to be partially liable, then client shall reimburse the consultant based on the client's share of liability. This is also not what the code says. This is where the client is going to reimburse you. And as I said, that pay and chase, that gets tricky, and Scott's going to talk about that in a minute. And then we've got the last one, which we've seen this, consultant agrees that if client determines in client's sole judgment that the alleged negligence of consultant is a significant factor. I'd like everybody on this rhetorically to think about how many of your clients would say, gee, you're right, Mr. Architect, you didn't cause this, I'll pay for it. The reality is most clients are going to point to you and look for you to pay for things. So the whole purpose of us having 2782.8 is to give you that tool to try to fight back against that. Next slide, please. And Brett, I think this goes back to you on the reimbursement.
It does. And I love that last clause, David, where the client gets to decide. You're absolutely right. Ask your client that question. They're going to tell you this is your problem. But when it gets to defending your client, first off, not a lot of firms can afford to do that. But some can. And to the extent you agree to do this, understand this can be really expensive. Do not go into this with the notion that I'm just going to go ahead and get this money back from my client. I don't know if there's any client entities on the phone, but I think they'd probably agree. A lot of them aren't just sitting on a slush fund of cash. It's really hard to get that money back. Once you pay that money, it's pretty much gone. Especially if it's going to their counsel, they're not sitting on it. It's going to be difficult to get it back. And if you think that you can sue your client and get it back, I don't know if that's the best idea either. Think about what suing your client does to your client relationship. Are you going to get future work from that client? Are you willing to spend $100,000 to chase after 50? And what's really important about this, is when we are pursuing fee claims, guess what? That is not covered by insurance. That is money out of your own pocket. If you did not get paid or you're trying to get money back, you're going to have to spend that money. So it goes into your calculus of how certain do I think I am that I can get that money back? Is it worth actually paying those litigation costs to get whatever I think I'm owed back after the case? It's just not, I don't think, a very realistic standpoint. And I want everybody to be sort of cautious as you're looking at these contracts. Just really think through, well, what does this mean to me? So we'll go ahead and go to the next slide. And I think, Laura, you were going to take this.
Yeah, we wanted to hit on just a few other negotiation strategies because we understand that there are business decisions to be made and there's lots of things involved in that. We really agree, this team, that the duty to defend and the other indemnity provisions, because of their lack of insurability, because of how they raise the standard of care, are really central to this circle you see, these concentric circles. But that doesn't mean it's the only decisions that you all are making as you move forward. So we're going to dig a little deeper into those inner circles and then touch a little lightly about the areas in the rest of the contract for all of you today.
Thanks, Laura. Next slide. And what I really love about those concentric circles is it kind of gives you a little bit of perspective of what we're talking about. People will come to me and they say, well, is this duty to defend language bad? And unfortunately, you're going to get an answer, and David give you the same answer. It depends, right? It depends on a whole lot of things. It depends on what we're saying in that indemnity provision. It depends on everything else in the indemnity. It depends on other things in the contract. It depends on your client relationships, all these different things. I know a lot of my insureds are signing bad contracts all day long, and I'm okay with that as long as they understand it and they can manage that risk. So look back to this slide. We looked at this slide earlier in the program, and what we're going to do is capture some of those concentric circles. In the next slide, we're going to talk about the defense obligation, and then drill down into things that happen elsewhere in the indemnity. So we talked about the upfront duty to defend. We've talked about split or bifurcated indemnities, all these different things that we can do with managing or negotiating that duty to defend. And then it also depends on who else that we're talking about in this provision. Next slide, please. Now, this slide here, this is a little bit of the world according to Brett Stewart, and I think David might agree with some of this, and I'm gonna ask him to chime in on some of this. A lot of times people will say, well, what is the best thing to do? Now, if you ask an insurance company, we're going to tell you not to defend your client. And in California, when David talked about Civil Code Section 2778 embraces the cost of defense, if you just cross out the word defend, you're still going to owe that obligation. Isn't that right, David? You're still going to have to pay
exactly
that.
Right. And
Right.
I told you earlier that we're going to put a pin in that. We saw in 2778, it says, unless a contrary intention appears. So simply striking out the word defend is not sufficient. You'll see that as Brett's written this up as alternative language, that he's also added, but not defend. And that's important, that in order to really make sure you get around 2778, that you have some contrary intention, but not defend, or architect shall not be obligated to pay the upfront defense of the client. Some language like that. That's the key part there.
Right. Now, we talked about bifurcated indemnity briefly. David, I think you hit that already. Hey, maybe we come up with two of these things, right? One is I'll defend you for anything arising out of my non-professional services. And then for my professional services, we'll say not defend. Firms have some limited success with that. Now, we go a little bit further down the ranking list here. Reimbursement of reasonable defense costs. Right? Consultant have no obligation to defend client, right? We're getting rid of that defense obligation. Consultant will reimburse reasonable defense costs. Where did you see this? This came from our definition of damages. Now you might say, well, I'm not an AXA XL policyholder. And to that, I'd say that's okay. I would still recommend that you take this language, and David, I'd love to hear from you on this. Take this language, put it into your policy or into your contract of indemnity. What it does is it takes that initial upfront burden off of you to possibly write a check every month, and it tacks it on to the end of the case. And I will tell you, in my experience, a lot of times carriers, David, how many mediations have you been to at about 3:00 in the afternoon? We're now talking dollars. So if you have language like this, maybe you're not our insured, you might get a reservation of rights letter, but at the end of the day, what I'm really concerned about is easing that upfront burden on you. And when we talk about what's best for our clients, we really want to make sure the client's going to be made whole at the end of the day, but we want to have a contract that makes sense, that's reasonable, that's fair. And then shall not exceed the proportionate percentage of fault. Now we're getting into the 2782.8 language. And this is where, when David talked earlier, but this is a ceiling, not a floor. Any comments on that, David?
Well, and let me go back to the reimbursement issue. I use language very similar to this almost every time I am asked to review an indemnity clause. And part of that is also a recognition of, let's face it, something upwards of 97, 98% of cases settle before getting to trial. And in all the years I've done this, I can't think of a single settlement where there's been a specific discussion of this part is defense or attorney's fees and this part is damages. So at that point, it kind of gets jumbled up and resolved. Certainly, there's no promise of how it gets treated by your carrier, but it'll end up getting resolved and wrapped up. On the not exceeding the proportionate percentage of fault, remember what I said at the beginning. I like working with architects because, in my experience, architects are willing to stand behind their own work and stand up for what they did. You shouldn't be obligated to pay for somebody else's. And if you talk to your clients and say, would you pay for somebody else's fault? Would you pay for my fault? They're going to say no. Well, then why should I pay for yours? And I saw that somebody in the chat asked the question, what about public sector contracts that are take it or leave it terms? Well, you still have to try to mark it up. And I never tell a client, do not sign a contract. That's your food on the table and next month's rent. So I'm never going to tell you not to sign it. Ultimately, it has to be a business decision on your part, which, as Brett said, is going to depend in part on the client relationship, the size and nature of the project, or any number of considerations as to how you're going to manage the project and manage your own risk on the project. But I
David,
do
could I
think,
jump in there just a second? Because I think what you're getting to, Mark, that asks that question, and we see it all the time, being a school architect myself, is but the other architects signed it. Defense, right, David, you're grunting because that's what happens to us. We make a business decision, and 2 out of the 5 architects in the pool sign the agreement, and then without, maybe with some negotiation or without it, but it leaves everybody who's trying to hold a line the bad guys. And I think what we're hoping to do with this webinar is understand everybody has to make business decisions for all the reasons David said. But the more that we can sing with this from the same sheet of music about insurability, about our responsibility, and all of those things, I think the better we are in the long run in this profession. Sorry, editorial comment
Yeah,
there. Yeah.
that
no,
is awesome,
absolutely,
Laura.
Lauren.
Yeah.
You have that experience, and I know that's what you deal with day in and day out. And I know Brett and I see it quite a bit, but you probably even see it more. So, Brett, back to you for your last couple of comments on this slide.
Yeah. So a lot of times folks will say, well, how about this negligence trigger? So, a lot of times we see these indemnity provisions and it's arising out of or relating to your services on the project, which is actually broader than anything you agree to in your contract. Maybe you did a favor, maybe you did something that wasn't captured by an ad service. And now anything that arises out of your services that you provided, you now have to defend this client. So another sort of walk back on that. And if you ask an insurance company, we're not going to comment on it. We're going to tell you, number one, right? Disclaim the duty to defend, because our advice is conservative. It is coverage based. But I see a lot of clients say, you know what? And it kind of goes to the comment earlier about, well, what about this take it or leave it, or something that's really bad, right? A lot of the commercial reality for a lot of our firms is they say, well, I can't mark it up like Brett Stewart would mark it up. It's going to be all this red. They're going to freak out. What are some of the minor changes I can make? And sometimes it's just saying to the extent caused by the consultant's negligence. That way we have this element of causation that is attached to it. Is that the same as saying, reimbursement, your obligation to defend shall not exceed your proportionate percentage of fault? Not exactly, but it is a way to recognize that we don't know what our negligence did to cause damages, typically at the very outset of a case. David made that comment, and typically when we see claims come in or lawsuits come in, there's a lot of different concurrent causes, and we just don't know what it is. But back to Laura's comment about firms that do agree to just sign whatever's in front of them, it's just not, when we think about what's best for our clients, managing expectations, if a client goes into that expectation that they can just spend all sorts of money and they're going to get it back, it's not covered by insurance, and most architecture firms don't really have a lot of assets. So it's kind of going to leave your client in the lurch. So the more we can negotiate these things to make them fair and even insurable, I think the better off. And then finally, I see from time to time the mutual indemnity provision. You got to defend and indemnify me for anything arising out of your work. Well, yeah, you better do the same back to me. Sometimes those things can cancel each other out, but I wouldn't hang my hat on it. A lot of times when we talk about indemnity provisions or professional service agreements, I have this thing where I call it the disparity of obligations. You got to do all these things, and the client's got to make a couple decisions and pay you. And typically that payment clause is based on undisputed amounts. So it's not always fair, but sometimes, and David, maybe you've seen those things cancel themselves out from time to time.
Yeah, I mean, I certainly have seen some of those things cancel themselves out. I want to address, somebody asked a question here. I think it's Rona Rothenberg asked this question. about having to do with what are a bit outside of the normal professional services. And Brett, it kind of gets to that whole list of obligations you were talking about. If you actually look at California Business Profession Code 5500.1 that defines architectural services, it's really very broad. Advising clients, even working with estimates, any of those types of things will all fall within architectural services. So being an architect is not just about drawing plans and putting your stamp on things. It's a lot broader than that. And I would certainly make the argument that 2782.8 would apply to all of those since they fall within that definition. The question was asked on there that this person clearly has dealt with these a little bit, as many of I'm sure our attendees have. The 2782.05 comment that's on there, that really applies with subcontractors. So that would probably take a little bit more looking into whether that's going to fit in at all on some of those ancillary services. But I think that 2782.8 would cover those. So
I think
next slide.
And I'll hand this over to you, even though David and I could talk about that last slide for probably an hour. I'll hand this over to you. We can talk about some of the other things that fall within that concentric circle.
Absolutely. So the reason that we really put this slide in here is, as we were talking about putting this together, is we've all seen these clauses that start listing all these different people. And then we talk about how it works in application. And I have seen the cases where the general contractor comes along and says, hey, I'm an agent of the owner, therefore you have to indemnify me. And while you can say, well, that's not what I meant when I signed that, the fact is that now it's going to be interpreted by a judge. And I hate to say it, but a lot of the judges do not understand this stuff. You know, you might have a judge that spent their entire career as a district attorney, and they haven't, thought about contracts class since law school or the bar exam. So one of the efforts, and Laura talked about this as being some of those prime directives, if you will, at the beginning, is getting a contract that's clear and unambiguous. Because when you have ambiguity, well, that's why I have a job, is to fight those things out and figure out who meant what. So when we start looking at those standard lists that we see, we've got this listing that breaks it down. Contractors, no, you don't want to do that because that could clearly be the general contractor or the construction manager. So you don't want to include that as somebody that you would go ahead and indemnify and certainly not defend. The consultants, same type of thing. It could be a geotechnical. I love working with geotechnical engineers. It drives me crazy when I see my architects responsible for them. Civil environmental engineers, site planning, a lot of those things. You don't want to pick that up and suddenly be responsible for that. Assigns. Well, there's some where that could be okay. Things like related entities. Sometimes you might sign a contract with a developer that has an LLC that takes over the project. That might be okay. But I've also had the lawsuits where the school district assigns the indemnity rights to the general contractor. And now all of a sudden the general contractor is coming back against the architect saying, you've got to pay all of this. So you've got to be careful about how that's set up. The agents, again, if it's anyone acting with apparent authority, well, that's probably a little bit more broad than you want to go with. The lawyers, I can't imagine any circumstance where the architect would defend their client's lawyers or indemnify their client's lawyers, or the insurers, that one. In fact, there's one that's not on the list here that we were talking about right before it started, which is volunteers. So, think about the school district. This is the one Laura was talking about right before we started today, the volunteers. And I chuckled and said, yep, architect, you just bought the PTA that you're going to take care of as well. So next slide, please. This is the elsewhere in the indemnity. And remember those concentric circles. This one was a little bit further out. It's not the duty to defend, but these are the types of things that now get right to the heart of what Brett was talking about on what's covered. And one of the keys is to make sure that your indemnity obligation is tied to your negligence. We saw in that troublesome clause earlier that it just said arising out of the architect's services. Well, that doesn't mean you did anything wrong. You could have done everything right, but now under that language, you're obligated to defend and indemnify. And by the way, your insurance policy is not obligated to pick that up if you didn't do anything wrong. If we really look at the language of 2782.8, what it says is that it's arising out of, pertaining to, or relating to the negligence, recklessness, or willful misconduct. And personally, I just use that exact language. It's really easy to point to the code section and say, this is what it's allowed. That's what we're going with. But that way, you know, you've got it tied to negligence, recklessness. Those would be covered by your policy. Willful misconduct is typically not covered by your policy, but I certainly hope that none of the architects are out there willfully doing something wrong. The types of damages, you want it to be tied to your negligence. Okay, so things like fines and penalties. Well, that's probably not tied to your negligence. And for the client to be assessed, those fines or penalties, it probably would get beyond your control anyways. So you want to make sure that you're limiting it down to the damages and liabilities that are arising from your negligence. Next slide.
So you've got to defend, right? We talked about, and none of the advice here is don't sign an agreement that has a defense obligation. It's more about understand what it is, what it means, and how are you going to manage that risk? What's going to happen within the contract? What are you going to do outside of the contract? What are you going to do in terms of quality management and staffing and all these different things? But when we think about that upfront duty to defend, we see this show up in contracts. And it's not, it certainly has been happening long before 2018. So what do you do with it? Well, a couple options are you just pay it, right? Or you pay what you think you owe. I don't recommend that because that's money coming out of your pocket. And like we said a couple times on this program, you don't really know up front when a claim comes out, just what is my liability? Now, some of the big firms, maybe they pay that amount. I don't know. But for most firms, they can't really afford that. Now, one of the things I've seen happen a lot when we have a claim is, and it works for especially more discrete issues on claims. You say, look, I understand there's a defense obligation in this agreement. I cannot defend, my insurance isn't going to pay to defend you. They're not going to hire you an attorney. They're not going to file an answer on your behalf. But I'll tell you what I can do. I can take that issue. I can defend that whole issue. I can hire the experts on that issue. I will litigate that issue. I'll take the depositions on that issue. We will do all of that, right? Maybe it's a mechanical issue. Mechanical's under your contract. There's a heating, cooling capacity issue. Maybe you and the mechanical are going to split that. My point being is that's a great way. It's going to be your fault. It falls under your contract, or maybe it's something you actually did or didn't do properly. And that's the allegation against you. Then let's go ahead, hire the experts, defend that issue. And a lot of times that can mitigate the impact on the client. David, do you see a lot of success with that as well?
Yeah, I do. And I've actually used that a number of times, particularly if you've got a lawsuit or a claim that's written so that you can sort of clearly delineate. There's almost always going to be a whole hodgepodge of claims. And a lot of times that might include, hey, owner, you didn't pay the contractor on time. And now there's a prompt payment claim. Well, that's not the architect's fault. So why should we start paying for attorneys that are going to defend that? Or there's something related to some other outside consultant. Why should we take care of that? And through that type of process, I have in the past been able to do exactly what you said, Brett. Let's narrow it down to, here's the things that fall within my basket. We're not going to pay for your attorneys, but we're going to stand side by side with you, and we're going to fight this. You fight your issues, we'll fight our issues, and let's go into it together. It relieves you of that upfront financial exposure. And frankly, it also builds your relationship with that client, which most architects I know, they don't mind good client relationships. So,
You know,
yeah, Brett, I have seen success with that.
That's a great point. And I just want to underscore, nothing in this program is talking about you ducking your liability. Clients love it when you take responsibility for the things that you've done wrong. And this is how we do it. And there's a time and place to do it, right? The claim comes in, we've tendered it to the carrier, we have defense counsel involved, and we make a decision that, look, this is our issue. We're going to take it on. And I see, I've seen some pretty nasty claims where our architects have stepped up, and that results in repeat business. The clients are very happy about that. You said another thing, David, and I don't want to take too much time on it, but I think it's worth mentioning, and that is working with your client to resolve disputes. We always encourage that at AXA XL. We're all about working with your client to resolve disputes. Sometimes it's a direct a direct dispute. Great, let's sit down, let's hash it out, let's try to mediate it. But it might be a type of case where maybe a contractor is suing the client. Contractor says, hey, I'm owed $5 million due to additional construction costs based on these, defective plans. And that client comes to you and they say, well, what do you think? Help me out, right? That's a circumstance. Most policies have this circumstance reporting mechanism. You get it over to your carrier and we can work with you on that. But a lot of times we like to work with you and the client to help resolve that issue. And David, that was just a great point that you made that I wanted to drive that home. And then finally on this, you can, a lot of times we have this, we talked about disputing the liability. We don't know upfront what our negligence is. But what I don't recommend is doing nothing. This tender of defense comes in. You've got to address it. You've got to deal with it. It depends on the contract language. I don't know, David, you want to share some insights on that?
Yeah, since we've been putting this together, I've been trying to think of a circumstance where I've seen a design professional do nothing and it played out well. And there's not many of them that I can think of. And when I say not many, maybe one. You've got to step up and do it. And that's part of being a professional is step up and say, hey, how can we help? How can we help fix your problem building? How can we help avoid the things that really aren't a liability, and taking responsibility? And I see that William Haynes asked the question, to what extent does the defense embrace paying for the client's insurance company legal costs? Well, there's really not a distinction. If the client has their own insurance company that's hiring lawyers for them, that's the client's legal costs. The fact that their insurance company is paying for it doesn't really make a difference. And so, yes, a defense obligation would mean the architect paying for any of those lawyers that are defending the client. And we certainly are trying to help give you some guidance on how to avoid that, but putting your head in the sand, not a good way to approach it.
Thank you, David. I'm glad you caught that question because I thought it fit right nicely into that area. If we go to the next, what are we doing? Right? What are we doing about this? I mentioned early that some of the education strategies are intended to help our clients see contract provisions from our perspective, but also where they can damage them as clients. So the advisory committee has prepared a detailed memo explaining the impact of this single provision on our relationship. For those of you who are familiar with the QBS memo, this one is similar to that, where you can use this memo as the talking points for a conversation with your client during those negotiations, or you can request, and Scott Terrell, our legislative rep at AIA California's email is there to send it on your behalf. I will tell you that in the area of QBS, our colleagues at ACEC and other places have full-time people that send this memo, the QBS memo, every day. And that's their full-time job. We don't have that, but we will try and get these out as immediately as possible. We do hope to be able to deal with this legislatively or regulatory means in the future, but that's only works if there's an appetite by the legislature to do that. So in the meantime, we're in conversation with other professional organizations like ACEC to be partners in this effort. I also want to thank my school architect colleagues who have been amazing collaborators on this memo. So when we give you the information and the slides from today, we can also include a copy of this memo so that you can use it to guide your future negotiations.
Laura, if I may, one of the important things about this memo and this idea of having Scott send it out, if you can even look at sort of the draft of it there, there's no reference to what architect asked for it.
Mm-hmm.
So now if you are on a QBS or any kind of public project where you're going to get scored and then shortlisted and invited to interview, if that public entity receives this memo, they don't know what architect asked for it. And that's an important concept there, because the QBS, we saw that. If you were the one that bugged them about QBS, well, guess what? You didn't get shortlisted.
Yeah.
So part of the idea that we came up with on this was to make this anonymous on behalf of the architects.
Yeah, and I think, the first choice is always to negotiate directly and build that relationship through that negotiation. But it doesn't mean we can't have a both and, right? So that, and we did find success and have found success with that QBS memo that has sort of a higher calling than just one individual architect, when all around them, maybe their colleagues are agreeing to those terms and conditions. So really excited about this effort as a stepping stone to getting this cleaned up maybe once and for all. So next, please. We mentioned other risk management considerations, and I think we're just going to touch on these very quickly here at the end of our presentation. The concentric circles, right? The rest of the contract, everything from raising our standard of care, free redesign services, and just being mindful of your fee and payment terms. You can see the others on this list here. You should be looking carefully at those as you move forward. It's important to me, and I'm not going to put Brett or David on the hook for saying this, but one of the things that worries me is we continue to diminish the professional role of architects and agreeing to things that are really more vendor related and less professional services related. And again, we all have businesses to run and risk to assess, but we want to see if we can collectively understand the implications on our business and our profession, and push back a little bit, see where it goes with those clients. Next, please. And so, the decision to pursue a project in the first place relies on things well beyond contract language, client relationships, their reputation, your internal skills and ability to deliver. We all go through a go, no-go process, whether it's intuitive or rigorous. You may make walking away for these complicated provisions very difficult. So we hope that the discussion gives you the tools in your toolkit that'll allow you to make good, solid decisions for your firms, minimize the risk to you and to the profession, so we can all get back to the important reason that we exist, to do the great work that we can all be proud of. So we're going to open it up to Q&A. I know that Brett and David have agreed to stay on if that's necessary. I think we've captured most of things as we're going here. Let's see. We've got, please discuss what you're seeing in 2025 on the negotiation of contract insurance limits with your architect clients in relationship to total design fee amounts. Brett, that sounds like it's got your name all over it.
And I'm going to defer to David in a second, but we are seeing a trend in higher limits. Clients are asking for higher limits. It's not uncommon for someone to come and say, I want a 10-10 policy, $10 million per occurrence, $10 million aggregate. For most firms, you can't just agree to that. And this is where, when it comes to, we didn't talk about the insurance piece of this, right? But when it comes to insurance, make sure you're just interacting early on with your broker. Most firms cannot get a $10 million limit. Carriers just aren't going to extend that out there. And this can be a real sticking point for some clients. I see on bigger projects, it might be 20, you might have to go out and go to London and build a tower of insurance. There are different vehicles that are out there. There's specific job excess endorsements, but carriers only hand a few of those out, and on the right types of projects. You're really putting a lot of money out there. So I guess my first thing is, and David, I'll let you maybe respond to kind of what you're seeing in that space. We're seeing a lot of it nationwide. And sometimes we see firms get into trouble because they agree to it and then they can't get it because they didn't talk to their broker first.
My favorite part of any contract that I review is the insurance section, because I typically get to say, discuss with your broker and skip to the next section. And the reason being is I don't know the insurance that my specific clients have or where they are with their underwriters or et cetera. But you're absolutely right, Brett. And I've actually thought for a number of years that it's probably wise for a lot of the architects in California to maybe get a little bit higher than those old school $1 million limits. And one of the key things to understand here is that for virtually every professional liability policy I know, it's called an expense within limits. So the moment that you have a lawyer that starts working with you to defend a claim, that's coming off of your limits. And the reality is that over the last 20 years, everything has gotten more expensive. The cost to make the repairs, the contractor's daily expenses, the legal fees, everything has gone up. And it just means that old $1 million policy may not be enough anymore. And so I am seeing a push. I haven't seen as many 10 or 20s. Brett, you're working on some big projects. But I am seeing a lot more 5s. And that is something that, as Brett talks about, before you agree to that, you've got to talk to your broker and make sure that's okay.
Yeah, and what your umbrella policies and all the other cobbling together that many clients don't understand either.
Yeah. And also, look, insurance is about finding that right limit, that sort of sweet spot. If you just have unlimited insurance, you kind of paint a target on your back as well. I don't want to see you wind up in a situation where you have excess exposure. I mean, there are policies under $1 million. Some carriers sell policies for, mostly for smaller or solo practitioners, but, a couple $100,000, $100,000. I don't think we do policies that low anymore at 100. But my point being is you want to have enough that's going to help cover a situation. But I mean, you could have the leanest defense counsel, and it's easy to blow through $100,000 in costs. These are expense within limits policies, so just keep that in mind. So yeah, talk to your broker about what that is. My biggest concern is just don't agree to stuff in, especially when it comes to that insurance piece, without talking to your broker. And your broker is going to talk to your carrier. That's the other thing too.
A couple quick questions. I know people are starting to head off, but we still have a lot of people here. So one of the attendees asked an example of what you mean by architects taking more of a vendor role. That was what I said. And what my concern is that we often are seeing contract provisions that are more contractor focused or vendor focused, not professional services focused. Bleeding into our contracts. And unless we respond to those or push back on those, that will just continue. That was what I meant by that. So I want to be clear. We weren't talking about making us a vendor. I was talking about seeing those things seep into our agreements, and not from a position of trying to get away with something. It's usually just a copy and paste that we'll see from another agreement. The last question we have in the chat, in an agreement, what is the difference between indemnification, client indemnity versus indemnification, and the absence of client indemnity?
So are we talking about, make sure I captured this correctly, a policy or a contract that does not have an indemnity provision in it? I think that's what it's asking. And at the end of the day, you're responsible for your own mistakes. I tell I say this, I know it's not a reality for most folks. You don't have to have an indemnity provision in your agreement. You can tell the client, we're just not going to have it. I'm still going to be responsible for my mistakes. And that's a big pill to swallow for a lot of clients. But when we talk about making these indemnity provisions insurable, it's kind of like we're making it so you're just responsible for your mistakes. I don't know, David, any thoughts on that?
No, that's also how I was reading this, and I hope that's what the person asking the question meant by it, is if there's not an express indemnity, well, first off, as I said earlier, you've now just gotten rid of the whole defense obligation. But it doesn't mean that you would not be responsible for your mistakes, because at that point, it would fall back to what's called equitable indemnity, which is just fairness. If you caused it, you pay for it. But it does eliminate that defense issue. So there is going to be an element there where you're going to have to step up. And by the way, and again, Brett, I defer to you, but I've never seen an equitable indemnity issue that's excluded from coverage, because you are talking about, hey, this is just what did the architect do wrong?
Right. You get sued for not being fair. That's basically what it is. You make a mistake, like this isn't fair. I mean, that's what equitable indemnity is. And that typically, I can't comment on coverage on all claims, but that's typically something that's going to be covered, right? You did something that fell below the standard of care. And just sort of a corollary to that question, I don't want to take up too much time, but also standard of care provision, that provision in your agreement that says, here's the standard by which my professional services are judged. That's another thing. If you struck the whole thing from your contract, you are still governed by what your competitors down the street would do, practicing at the same or similar time on these types of projects. So you're still held to the standard of the industry.
I see that the person asking the question said that this isn't in an agreement. And unfortunately, if you've got an agreement that says indemnification, absence of client indemnity, frankly, without seeing the language, I have no idea what that's meaning or referring to. But on the standard of care, Brett, you're 100% right. Even if you completely take that out, you're held to the average standard of care. Specifically in California, it's jury instruction KC 600, that an architect is held to the standard of other architects acting in the same or similar locality in the same or similar time period. So that's how you're measured. And to be very careful that your contract does not include language that changes that or makes it worse. One of my partners came up with the word brochurebiage. It's we will provide the best service, the most efficient service, which you're going to say all that to try to get the client. But once you get that contract, you don't want to have that superlative language, because you could actually contract yourself out of insurance coverage.
Right. We're C-average architects.
That's it.
That'll win you a lot of work in your proposal documents.
But I want to just make a comment on that. And when we talked about, and this isn't really part of the program today, these concentric circles, right? That's what we're talking about, that other circle. What else is in your agreement? And there are things that you can mitigate that, or things you can make this duty to defend way, way worse. So on the last page, and I think, Sarah, this program's going to be available as a PDF for attendees, but on the last page, you could saw, the go, no go, and all these other different things that go into it. These are all considerations. And this is why it makes it so hard for someone like myself or Laura or David to say, well, yeah, that clause shouldn't really matter that much, or that, or this does matter. There's really no one size fits all approach, because there's all these other things that come to bear on this contract and in the environment around you. So just, I will say this, I have to say this, it's so important for folks to engage with legal counsel. Don't rely on your broker. Don't rely on your carrier. We're going to give you super conservative advice, and you'll never win on a project based on the advice we give you. But talk to your counsel. And I tell folks, talk to your counsel at least once a year. Here's my terms and conditions. Has anything else happened that I need to know about? People like David are out there. They're in the trenches. They're litigating these issues. They're seeing these issues. They're talking to their colleagues. This is not a plug for defense counsel. This is a plug for you to spend money where you need to spend it, so you don't wind up on the back end of a claim scratching your head thinking, I wish I would have done things differently. Because that's a theme. When I handle claims, there was always, it seemed like a common theme, there was going to be a little bit of regret. Had I only spent a little bit of money on the front end. especially on bigger cases or clients you haven't worked with. It's just really important to do that.
Well, I am going to thank our panelists, David and Brett, and reiterate that the slides and recording will be made available on the AIA California website. They obviously, what they had to say went along with the slides and was really valuable to all of us. And please reach out to AIA California to access the memo, both on QBS, which is a long time memo for us, but more importantly for today's conversation, our duty to defend memo, and ask that that be sent on behalf of our profession. So again, thank you guys so much, and we'll see you all soon.
Thanks, everybody.
Thank you, Laura.
Bye.
Thanks, everybody else.